In other developments now, the relationship between franchisor and franchisee has come under scrutiny following two recent court cases involving well-known franchise brands Roman's Pizza and Cash Crusaders. This has brought to light how the franchise sector deals with regulation, legalities and authority. Franchise Association of South Africa CEO Fred Makgato speaks to us about these developments. Thank you so much for your time, Fred. I think let's first unpack FASA's reaction to both these cases. Recently, Cash Crusaders.
Son and the viewers, I think for us, this is not normal, if I could put it that way, in that we have read in the media because we were not approached to deal with any issues. That 78 of the franchisees have gone to court and are proceeding to cancel the franchise agreements. For us, we don't know what the merits are, and it is very difficult for us to comment on the whole issue because it's before court is an interdict, is not yet finalized, and we will await, I think, the final judgment, and hopefully we will engage with both parties. But for us, I think that it would have been better if we are brought up to speed about the issues that affect their relationship, because we do appreciate and know that the franchise agreement is a partnership between two parties who wants to grow a business. So when we have this kind of issues where parties now don't agree on certain issues, it becomes a concern for us.
Fred, that's a bit of a concern, seeing that FASA as a body was not even asked to mediate at least. What do you make of this, and maybe what does it say about the fragmentations that exist within the franchise industry in its current state, despite the progress that has been made over the years?
One of the issues that we offer is mediation. But I think that the issue, as we are talking from what we think, is the interpretation of the agreement or the terms of the agreement or the amendment of the agreement. So that I don't think that falls within our scope because the terms of the agreement can be interpreted according to what either the facts are presented before court. Our role is to deal with mediation issues that can be where parties can actually agree on. But when you deal with interpretation of process or terms of agreement, it becomes very difficult for somebody to mediate on because you need a clear indication what is the meaning of that clause to the parties. And we are informed that the issue is, as we read in the media about the change of the term in relation to either levying of the initial fee for loan renewals. So that is the scope that falls within the NCR. But I think with amendments to that contract, the court can only interpret whether is it allowed, is it permissible or not. So I don't think we will be able to deal with that issue.
On a broader scale, is FASA's position that there is fairness in this relationship between franchisor and franchisee?
Look, one of the issues is that we don't know as to how long were those franchising part of the franchisor. Because at times you find that it's a long-standing relationship because of the change in terms of the term, as I think that the franchisor has obtained legal opinion from the lawyers about the levying of the initial fee, whichever opinion the franchisor wanted to implement. And I think that there was an objection from the franchisees. So we don't know whether going forward the franchisees will be allowed to continue with what they've been doing vis-a-vis the legal opinion. So I think that's the issue to look out for, because it doesn't only affect this franchisor and the franchisee, it affects the entire industry, all the financial sectors, to whether a credit provider is allowed to charge initial fee time and again when there is a renewal and not a new contract. So it's a very interesting space, but we'll keep on watching.
What lessons should we be taking out of this that would serve as maybe a litmus with regards to a trajectory going forward within the franchise sector that dictates to how the balance is struck when it comes to fairness?
One of the structures in place or the system in place in franchising is that because a franchisor tend to have plus minus 100 to 200 franchisees, we have members who have what we call franchise council, where the franchisor and the franchisee have representatives. They meet either on monthly basis to discuss issues that affect their business, because they understand that the continued relationship is both good and financial rewarding for both parties. So at all material times, they tend to find common ground. It only becomes a concern when parties can't find a common ground. But looking at the history, I think this is the first time that you have that kind of an issue.
Thank you so much for your insights on this matter. Fred Makgato is with FASA this morning on the Business Desk, talking to us about the recent legal disputes within the franchise sector.